Live stream. Okay. To my left is the Honorable Jim Wright. He is the former trial court judge of what court? 91st in Eastland, and then served for about, I don't know, 2 or 3 decades on the Eastland Court of Appeals. And he is sitting with us today because, as y'all both well know, the
We have no sound.
check it now. We've gotten that, and I think it should be live now. If it's not, if you don't have sound now, come back and see me. As you know, Steve Smith was involved in this case, so he is recused, and Jim stepped in to take that slot. And to my right is Matt Johnson, who joined us in January. So he's been here. I said a year earlier today, and he corrected me, and he said, well, technically it's only 9 months and 20 days, but you know, who's counting? I mean, let me say this, it seems like a lifetime. So with that said, argument time is 20, 20, and 5 for rebuttal. And Lane, you get to go first. And at this time you may, I didn't call the case, calling the case Becerra versus State, docket number 10-17-00143 CR on remand from a reversal by the Court of Criminal Appeals. And Lane Thibodeau for Mr. Becerra and Ryan Calvert on behalf of the state of Texas. And Lane, you may proceed when ready.
Thank you, Judge.
And I realize it did not get to let y'all actually announce that y'all were ready, but we will assume, given the delayed start, that you are ready. So you may proceed.
I can announce ready on behalf of Joe Louis Becerra, the appellant in this case. May it please the court. My name is Lane Thibodeau. I'm a lawyer from Bryan, Texas. I represent Joe Louis Becerra in connection with this appeal. Before I begin argument, or at least before I launch into the merits of my argument, I think it's important to note in the event that this court is not aware or has not already been made aware, when I was doing research preparation for this, I noted that neither the state nor I had noted the Court of Criminal Appeals has a case in front of it styled Laws versus State. It's PD-1124-20. It's on appeal from the Texarkana Court of Appeals. The Court of Appeals case was published, but it does not have a Southwest 3rd designation yet. The Westlaw side is 2020 Westlaw 60513.
I believe that case was being submitted today to the Court of Criminal Appeals.
As a matter of fact, it is. I was going to mention that it was submitted today.
We checked earlier to see if it had been decided today, as we sometimes do, submit them and decide them in the same day, but it was not. So just to let you know that it's still hanging out there. We realized that case is, my understanding, my recollection of it is that it is on the issue of the harm analysis for the concept of a outside influence brought by a juror, alternate juror into the jury room.
I am prepared to speak about laws because I have read the briefing. I went and took the liberty of reading the briefing both on the state and the appellant side. I will, the way that it impacts this case, at least in terms of my reading, is the appellant's appeal point or on petition for discretionary review is worded that 36.22, the juror misconduct statute, does not prohibit, or at least does prohibit, an alternate juror from being present during deliberations. So that case directly touches upon 36.22, the conversing with the juror statute that is at issue here. There are some important differences in the Laws case. In this case, in Laws, there is a procedural default issue that I believe is in play. that the Texarkana Court of Appeals wrote upon that is much different than this case. The facts of that case, very briefly, but I think it's important because, again, they do touch upon the merits of this case, were that the trial court in that case allowed the alternate back with the jury, but had a specific instruction at the front end, much like the Trinidad case had at the Court of Appeals level here, that the alternate juror could sit in with deliberations, but not participate, of course, and not vote. That was the instruction that was given. There was an objection that was voiced by the defense, but no request for mistrial. There was a perfunctory precursory motion for new trial in that case also filed that did not have any evidentiary attachments. And part of the issue that on PDR, on petition for discretionary review, and was extensively addressed, particularly by the state, was whether or not the claims were procedurally default. The Texarkana Court of Appeals had held that they were procedurally defaulted, and further held that the briefing on appeal did not match up with the complaint that was made in the trial court on the procedural front. However, they did go on and speak to one of the issues that I think is central in this case, and it's kind of a predicate threshold issue, and that is what the status of the alternate juror is under 33.011B. There was, particularly on the state side in the briefing and laws, there was a lot of discussion and a lot of argument concerning why, from their standpoint under statutory construction principles, the alternate is part of the constituted jury. And it becomes significant in this case, and I think is essentially a launching pad, or at least a starting point in terms of our case, because it impacts if the alternate juror is not part of the constituted jury under 33.01 or 33.011B, then the argument, of course, is that the alternate juror, once he or she gets into the jury room as an outside influence, that during deliberations is exercised against the pettit jury, the 12 pettit jurors. Unlike laws, and I certainly appreciate that CCA, Court of Criminal Appeals, has taken up laws, but the evidentiary record that we have established here, I think, in particular, emphasizes why I believe why I contend that the proper construction of 33.011B, the alternate juror statute, is that the alternate is not part of the constituted jury. Now, I will say that part of that is because I believe that if you read 33.011B, it does speak in terms of the alternate juror and why the alternate juror, that the alternate juror replaces the regular juror. There's several specific references in 33.011B that address specifically that the alternate juror replaces the regular juror or the regular jury. So there is a distinction drawn under 33.011B, I think, between in the statute itself, that the alternate is not part of the constituted jury. I think that Trinidad versus State, the Trinidad 2 case, as we've discussed it, is important in this regard. Trinidad 2 essentially says that.
Let's make sure we know which one we're talking about. Now, Trinidad 2 is the on remand, or is that the CCA?
That's the CCA.
Okay.
So Trinidad 1, for my purposes, is the original San Antonio Court of Appeals case. Trinidad 2, which is really the important case in this area,
right,
is the CCA case. Now, the language that is significant in Trinidad 2 is is on page 28 of the opinion, and I'm going to read it verbatim because I think it's significant in terms of making decisions here. In neither of appellant's cases, because there was Trinidad and there was Johnny Adams, there was two cases consolidated in which front-end instructions were given to jurors, the two alternate jurors and the pettit jurors. The alternate was not to participate. In Trinidad, it was allowed to deliberate. In Adams to be merely present, but they were instructed at the front end. The pettit and alternate jurors were instructed at the front end. No, you cannot vote on the ultimate verdict. You can participate and deliberate in Trinidad, but you can in Adams, no. Of course, in front of the Court of Criminal Appeals, they ultimately decided that the issue of participation and deliberation wasn't in front of them because there was no evidence in the evidentiary record that the alternate had actually voted on the verdict. And that is of course, a significant distinction here, but the language, some of which is dicta, that is important, is found on page 28. And the Court of Criminal Appeals writes, in neither of appellant's cases was the alternate juror allowed to vote on the ultimate verdict in the case at either stage of trial. As long as only the 12 regular jurors voted on the verdicts that the appellants received, it cannot be said they were judged by a jury of more than the constitutional requisite number of 12. That the alternate was present in the jury room during deliberations and may have even participated in all but the voting does not mean the jury was composed, and that's in quotation marks in the case, of more than 12 members for purposes of Article 5, Section 13. They footnote there and also say that 33.01 of the Code of Criminal Procedure, which is basically the statute that mirrors it, has to be construed in an identical fashion. The court goes on and says that the error in these cases, if any, in allowing the alternates to be present with the regular jurors during their deliberations is more usefully conceived as an error in allowing an outside influence to be brought to bear on appellant's constitutionally composed 12-member juries. My point here is that it makes no sense that the constitutional, that Article 5, Section 13 and 3301 would be composed of 12 jurors for any other purpose, but except for voting. That would lead, I think, or I contend to an absurd result. So in other words, 12 regular jurors can participate and deliberate, at least that would be the construction, but they can't vote. If there's evidence affirmatively as present here that the alternate voted under Trinidad, they're no longer there's no longer a constituted jury, if you follow what I'm saying here. The key is the vote. And it's my contention that because there's affirmative evidence in this case, that the alternate voted on the verdict, that in fact there was a constitutional violation and a statutory violation.
Let's go back and start taking this apart.
Yes.
And we're going to spend whatever time we need here. We did get started a little late. We're not going to cut y'all short on time. And in fact, we may spend more than the 45 minutes that have been allocated. But let's go back to the case you talked about, the Laws case, and then Trinidad, where it talks about the jury. And you made it very clear that your view is that the alternate jury is not part of the constitutional jury. And I ask, and you may not have this in front of you, but I note that Article 3526 defines the jury as the names that are called by the trial judge or the clerk, whoever's doing the jury seating after strikes are made, that is the jury for purposes of whatever follows, I guess you would say. And then you've got the alternate jurors. And that seems to be consistent with your reading of both the kind of the laws analysis as we have at the briefing that was done there and the Trinidad case. Then we talk about voting and the verdict. And I want to talk about the verdict. And Trinidad uses a term that I didn't particularly care for, but I wasn't working with the CCA on choosing words and phrasing. And they used that phrase, ultimate verdict. And when we look at the verdict, what verdict is it that you think is important and what vote is important? Because as you know, the record in this case is that the jury was polled and the verdict was in effect then voted on by the jury while they're in the box, trial judges at the bench, and the verdict as such, the piece of paper that they handed the bailiff handed to the judge, has not been accepted as the verdict of the court. At what point, in your view, is the verdict voted on, the ultimate verdict voted on?
Without the extra record evidence that's present in this case, the verdict that was received by the trial court and the poll, there would not be evidence otherwise. In this case, under this evidentiary record, it's my contention that because of the basically uncontroverted evidence from the juror affidavit, that ultimate verdict was a reflection of a vote that was taken in the jury room with 13 individuals, the 12 pettit jurors that were impaneled and the alternate, and that because no revote was taken, the ultimate verdict in this case was the verdict that was voted upon by the 12 pettit and the alternate juror. The fact that there was a verdict received with 12 individuals in the box does not change that fact. And there could have been, and I know we're going to talk about the curative instruction here in a little while, but the record is essentially uncontroverted here as far as I can tell, as far as I can see. And I would contend that under this evidentiary record, in the absence of contrary evidence, that the vote that was taken on guilt, and that's the important thing, the vote on guilt was a product of 12 jurors plus the alternate. There was no revote on it. That the fact that there was 12 jurors in the box at the time that the verdict was actually received as a result of having to deliberate on the special issue, the deadly weapons issue, doesn't change the record. And the record we have is that vote, and again, they do speak in terms of the ultimate verdict. I get that, but they also speak, Trinidad also speaks, and I think speaks directly to it, when the Court of Criminal Appeals, Judge Kieser says that that was composed of more than 12 members for purposes of Article 12:13. So by simply, when you read that sentence, if in fact there is evidence, as I believe that there is here, that the ultimate verdict that was received by the trial court, or that was a product of the pettit juror plus the alternate, I think that satisfies what is required under Trinidad's construction of Article 5, Section 13. I think if they had revoted, I wouldn't have a complaint. If there was evidence that there was a revote taken after the vote on guilt innocence, probably wouldn't have a complaint. But that didn't happen. And we have affirmative evidence, extra record evidence from the motion for new trial that did not happen.
So you think there's a not a break in the continuum between a tentative or preliminary vote in the jury room versus the vote that is taken when one side or the other decides to poll the jury prior to the trial court accepting the verdict?
Well, the fact of the matter is that at the time that the jury was polled, the 12 members, I agree, in the box at that time had all voted on the guilty verdict.
Well, more than that, after they were polled, after the poll was requested, each of them voted again and affirmed that was their verdict.
It was the 12 of their, I agree with that in terms of what was done and the polling that was done, but that vote was tainted, and I use that word inadvisedly, but I mean, the fact of the matter is that vote or that poll where each said, yes, that is my vote, was a product of a vote of more than 12. And frankly, if there's effect to be given to Article 513 and its requirement of 12, not more, not less than 12, then if the evidentiary record is as it is here, and that the vote in the jury room at deliberations, during deliberations, was for guilt, 13 people voted on it, Pettit plus 1, and additionally, that Pettit jury, that alternate juror participated in deliberations, made arguments of some type, that as part of the continuum contributed to the verdict that was received by the trial court when 12 jurors, after the alternate was discovered, they sit in the jury box and are polled.
So you think we just mark the word out ultimate in the Trinidad case?
No, because I think the ultimate verdict that was received by the trial court was a product of the vote of 13 individuals, and the record here affirmatively shows that.
Okay, let's talk about the record. Affidavit. Incident occurred in the courtroom or in the jury box, one more time, in the jury deliberation room, where a vote was taken, depending on what you want to call it, tentative, prospective, final, whatever. The vote was taken, and now you have an affidavit that says that. How is that affidavit admissible in light of the rules regarding we can't take evidence and affidavits of what goes on inside the jury room?
First of all,
We agree it's not a statement. Well, sort of a statement. A vote of yes is sort of a statement, but it's an incident that occurred in the jury room. And so where are we?
well, first, I would argue this is where it is significant, where it's important whether or not this alternate juror was part of a composed jury. This is why that is important, because if that alternate was not part of the composed jury in the jury room, then the alternate juror's participation in deliberations is an outside influence. If he is an outsider for purposes of that deliberation under 33.0011B, then the arguments that he made and the vote that he contributes to is an outside influence.
Well, if he's an outsider, he can't be a 13th juror on the vote.
Well, I mean,
He either is a juror or he isn't a juror.
well, I think under Trinidad, if you look at, and I'll address that directly, under Trinidad, if you accept what Trinidad says, that the only way that in a situation where there's more than 12, you have to affirmatively show that more than 12 voted on the ultimate verdict, this is the only way you can prove it. I mean, and that's one reason that.
But defense counsel has been complaining for years. There's impropriety that goes on in the jury room that we can't prove because we can't get our affidavits of what happened in the jury room into evidence. And why are we not handcuffed in whether or not we can consider that affidavit by those very cases?
I addressed this in my briefs and I give three reasons in the brief. First, the act of voting isn't part of the deliberative process under the 606B. Second, that because the alternate is not part of the composed jury, then he or she is or evidence pertaining to their participation in deliberations and the vote is an outside influence that is an exception to the general rule that during the deliberative process can't be gone into. That because they're not part of the composed jury, they are and can be, there can be a juror affidavit received from a regular petit juror, as there was in this case, because that alternate juror participation is an outside influence and admissible as under Rule 606B. And third, as I put in my, as I wrote in my brief, that in order to prove a constitutional violation as it's been interpreted under Trinidad 2, that to show this violation, you have, when there's more than 12 that are voting, you must show, it's incumbent upon the defendant, in this case Becerra, to provide affirmative evidence of a vote. The only way that you're going to be able to get that evidence of a vote to show that constitutional violation is by juror affidavit. There's no other way that you can do it by some juror testimony. And to say that you cannot prove a constitutional violation under Article 5, Section 13 by an affidavit of a petit juror like we had in this case, basically renders a violation without remedy, because you can't ever prove it. Would there be no situation where you'd be able to prove, at least in terms of extrajudicial records or extrajudicial evidence, the motion for new trial stage, and now even at 1107 collateral writ stage, that there was a constitutional violation as a result of more than the constitutional required voters voted. And in that situation, the rule of evidence has to yield to the constitutional provision. And I cited the Pena Rodriguez case as an example where that has happened. And it's a juror misconduct case out of Colorado, where there was a racially discriminated. There was a juror in the jury room making racially motivated comments, which a juror later signed off on an affidavit concerning. And the Colorado state courts had held, no, that was inadmissible because it was part of the deliberative process. So no matter how badly that racial comment may have tainted the jury, it was inadmissible because it was part of the deliberations. And the United States Supreme Court said, if you've got this intersection or this collision between a constitutional provision and understanding that's federal, that the principle is the same here. We've got a constitutional violation as interpreted by the Trinidad court, and a rule of evidence that would preclude the constitutional provision must take precedent, and it's admissible under that theory.
Okay.
I think specifically now, I think the second one is the point. The second issue, and I think that the undue influence, and this gets back again to what law speaks about and whether or not this alternate is part of the composed jury. Okay.
Well, now let's go to the other precursor that you had talked about that we would get back to, and that's the preservation issue and the instruction and the when the trial court was trying to fix this in real time, he proposed an instruction that did not instruct the jury to go back and deliberate. And as I understand your briefing, the critical is revote. You must cast another vote. Of course, the trial court didn't know whether or not a vote had been taken. He certainly had not received a verdict form at that time. And so why is it that the failure of the trial counsel to not object or request a further instruction, either object to the inadequacy of that was given or request a further instruction to tell them specifically, if you have voted, go vote again? Why is that not fatal to consideration of error on appeal?
I'm going to answer that two ways. First of all, by virtue of the fact that trial counsel requested a mistrial based on the circumstances that did exist at that point, I think I think.
I'll get back to that, but go ahead and give me your
Sure.
second.
I think that was sufficient to preserve the error. Second, my main criticism is not the harm is the vote, and the error is the vote, and we are left with what Trinidad says is error under Article 5, Section 13.
So at that point, you're saying, and I'm trying to make it shorter because we've already run substantially over. What you're saying is the error was incurable, therefore he could jump to the final remedy, if you will, a mistrial, and that there was no instruction that the trial court could have given at that point that would have fixed the problem.
I think that the court could have given a curative instruction that would have included that they restart deliberations. And if a vote, if any, had been taken, a revote would be necessary. I mean, this was 45 minutes, 46 minutes into the deliberations. They had a note 5 minutes in whether the jury had requested evidence, so they knew that.
Got all that.
But in addition to that, I think that the instruction that was given, that they simply resume your deliberation without the alternate being present, signaled to the jury at that point, because they had sent a question out for the special issue, and what he says, when the court said, and following instruction on this note, and he references the second note, which inquires about the special issue, you should simply resume your deliberations without the alternate juror being present. That basically told the jurors what's done's done, and the harm at that point, although the trial court couldn't have known it, the visiting judge couldn't have known it, the genie was out of the bottle. I would also say that at motion for new trial stage, all this was known. The trial court knew at motion for new trial stage that there had been a vote, and that error existed as it is construed. I mean, this affidavit was drafted with Trinidad in mind. Prove what this Trinidad says you have to do. And so the trial court at motion for new trial stage was aware of this. And in fact, at that point, and that's why we contend that a motion for new trial should have been granted at that point, because the trial court did know at a time when it could have fixed it by granting a new trial, that there had been a revote, that there had been full participation in deliberations, and importantly, no revote had been taken. So if the point that's taken, well, trial counsel, what trial counsel did was not sufficient at the time, certainly the motion for new trial stage, which is exactly what we're supposed to do with jury misconduct cases, right? We're supposed to talk to jurors and find out. Well, we did know at the motion for new trial stage that there was a vote, no revote was taken, and the trial court denied motion for new trial. And I think that's really where the wellspring of error in this case comes, is the denial of motion for new trial.
Any questions? Questions? Okay, thank you, Counsel. You'll have 5 minutes for a vote.
I give the podium to my friend Ryan Calvin.
I'm surprised y'all didn't ride up together.
Well, we probably would have, Your Honor, if
y'all
I
would
had
have
gotten
agreed
the
on the
letter
time.
of when I was supposed to be here, but I was here a few hours early.
You may proceed, room ready.
Thank you, sir. May it please the court and my good friend, Lane Thibodeau. I'm glad to see him today. I would like to begin where Mr. Thibodeau left off, which is addressing the issue of the hearing on and the denial of motion for new trial. And I think that really is the lens through which this court has to view everything else, because we have spent some time here this afternoon down in the weeds on statutory construction and what is the jury's ultimate verdict and things like that. But at the end of the day, this court's analysis comes down to whether the trial judge or the presiding judge in the 361st District Court, which was at that time Judge, now Justice Steve Smith, abused his discretion in denying the motion for new trial. And as Your Honors are aware, Judge Smith did not make written findings of fact or conclusions of law, but he did make an oral finding at the conclusion of the motion for new trial that any error, and it's important here that both the constitutional error and the statutory error, as Mr. Thibodeau correctly pointed out, were raised at the motion for new trial. And following that motion for new trial hearing, where juror Marion's affidavit was presented and all the evidence that Mr. Thibodeau discussed was presented, Justice Smith found in the record that any error was harmless. And what that translates to this court, for this court's purposes, is, let's assume, and I would like to make that kind of my jumping off point. Let's assume, for the sake of argument, I don't concede that it is, but let's assume for the sake of argument that the alternate in this case participated to a degree that violated Article 5, Section 13 of the Texas Constitution as a 13th juror. That would, as the law is very clear, as you well know, mandate reversal unless the record shows beyond a reasonable doubt that error did not contribute to the conviction in this case. And so Judge Smith's finding equates to a finding beyond a reasonable doubt, assuming constitutional error, that beyond a reasonable doubt, the alternate's participation did not contribute to Joe Becerra's conviction. And an interesting kind of point on that was not covered in the briefs, but I wanted to draw your attention to it. In the appellant's brief, Mr. Thibodeau made a point to say that the issue of the deliberations on the deadly weapon, the special issue of finding a deadly weapon, was not relevant to the constitutional error question in this case. I respectfully disagree with my friend Lane Thibodeau on that. Here's why. It's relevant as to the harm analysis, because think about what that jury, those 12 pettit jurors, did. As Chief Justice Gray, as you correctly pointed out, prior to a verdict being provided to the court or received by the court, those jurors were called out. They were informed by the trial judge, J.D. Langley, that alternate never should have been in the room, that he should not have been a participant in their deliberations, and they were to disregard any participation by that alternate, and they should go back and keep deliberating. After that point, all 12 pettit jurors were on notice that alternate did not, as Mr. Thibodeau pointed out in his brief, have equal voice and vote with them. They had not provided a verdict to the court yet at that point. Mr. Thibodeau, in his brief, goes to great lengths to point out that, judging by the juror notes, or piecing together by the juror notes and to some extent juror Marion's affidavit, the jury was already looking at the special issue of the deadly weapon at that point. Well, after they were notified of the alternate jurors' lack of equal standing with them, those 12 jurors went back in the jury room and they decided amongst just the 12 of them, beyond a reasonable doubt, that Joe Becerra used a firearm in the commission of the offense. Remember what the offense was: possession of a firearm. That's all the evidence required to be proven beyond a reasonable doubt to convict it. The verdict that Mr. Thibodeau complains about on appeal. So after the alternate was gone, the 12 pettit jurors went back there and decided beyond a reasonable doubt that the defendant, the appellant in this case, actually used a firearm. Necessarily, those 12 individuals decided that he possessed a firearm, and then that was reinforced when, as Chief Justice Gray, you correctly pointed out, Judge Langley polled those 12 pettit jurors, and each of them specifically and individually affirmed that a verdict of guilty was their individual verdict, as well as a finding that a deadly weapon was used. I want to go back to this issue, or this concept of, let's assume, just for the sake of argument, constitutional error. Does the record support a finding by Judge Smith that beyond a reasonable doubt, the alternate's participation did not contribute to Joe Becerra's conviction? And that's the question on the constitutional side. The fact that those 12 jurors decided that Joe Becerra used a deadly weapon after the alternate was gone, I think in and of itself shows beyond a reasonable doubt that the alternate's participation played no role in their verdict, did not influence them. As Mr. Thibodeau correctly points out, is kind of the key thing we're talking about, particularly under 3622, the statutory analysis. Was there undue influence? Going beyond the deadly weapon issue, though, Juror Marion's affidavit itself, at face value, speaks to that. He specifically says in his affidavit that the reason there was not a subsequent vote after the initial vote is because everybody agreed at some point, whenever in that first 46 minutes that vote took place, all 12 or all 13 at that point, people in the jury room agreed that the defendant was guilty. And so, as Juror Marion said in his affidavit, there was no need for a revote. I did want to point out to your honors, and it is worth noting, we're taking that statement about the vote at face value. I don't have any reason to dispute it. I would point out, and I did point out in the brief, though, there are some things in Juror Marion's affidavit that are not supported by the record. In fact, they're contradicted by the record. One, for example, is that he says the alternate remained with the jury until the entire jury was brought out into the courtroom. We know from the reporter's record that's not true. The alternate was removed individually at 10:31 a.m. The jury wasn't brought out collectively to be admonished by the trial judge until sometime around 11 o'clock that morning. He also says in his affidavit that the alternate was discovered when the bailiff came back to collect a note about the special issue of deadly weapon. And that was when the bailiff caught it. We know from the record that's not true. The bailiff actually removed the alternate at 10:31 a.m. That note was not received by the court until 10:46 a.m., 14 minutes later. In fact, and this is reflected in the record, I am the one who actually alerted the bailiff that the alternate was back there, and he went back and pulled him out. And that's also found in the record. But looking at it at the most stringent harm analysis that we can apply, which is the constitutional analysis, does the record show beyond a reasonable doubt that the alternate's degree of participation did not contribute to the defendant's conviction? I think between the deadly weapon issue that I've talked about, between the juror's affidavit on its face, and between the fact that the 12 pettit jurors were polled and each of them affirmed that that was their individual verdict, adding in the fact, and it is a factor in a constitutional error analysis under 44.2a, the existence of overwhelming evidence of guilt. When you put all of those things together, I don't think there's any question that Judge Smith was reasonable and was inappropriately found, supported by the record, that beyond a reasonable doubt, the defendant was not harmed by the alternate's participation. I want to go back and I wanted to address one point that Mr. Thibodeau made. I wrote it down when he said it. He said, in response to a question from you, Chief Justice Gray, about the admissibility of a juror's affidavit within the confines of a constitutional analysis, because there's two things going on here, right? We have the Article 5, Section 13 error, allegation of error, and then we have the allegation of error under 3622, the statutory violation. 3622, under these circumstances, is the only basis, as you pointed out, Chief Justice Gray, that is the only legal basis to admit Juror Marion's affidavit in this case, to address the issue of whether an undue influence was brought to bear on the jurors, on the 12 pettit jurors. And it was on that basis that Judge Smith specifically stated on the record at the motion for new trial hearing that he was admitting that. It was on the statutory side of the equation, not the constitutional side. Mr. Thibodeau, in his brief and then again today, has attempted to read into Trinidad a combination of those two concepts, the statutory error under 3622 and the constitutional error under Article 5, Section 13, in a way that just simply doesn't exist in that case. The court in Trinidad specifically made a distinction between the constitutional error and the statutory error. And that was the quote that Mr. Thibodeau alluded to. In fact, I believe in footnote 4 of the Trinidad 2 opinion, and I may be wrong on that, but I believe it's footnote 4, the Court of Criminal Appeals cites back to Trinidad 1, the San Antonio Court of Appeals original opinion, wherein the San Antonio court plainly made that distinction as well. They made the point that Chief Justice Gray, you made here today. If the alternate was in fact a 13th juror, then it's a constitutional issue. If he was not a 13th juror, then it was a statutory issue. And so those are different things. But in his remarks to you today, Mr. Thibodeau made the statement that the only way, according to his argument, the only way that we could ever know that an alternate voted in violation of Article 5, Section 13 is with a juror affidavit taken post-conviction in a motion for new trial. And I respectfully disagree with that. To show your honors an example of how that can happen, it didn't happen in this case, but it's a good example of how it can happen. There's a case that we both sides refer to in the briefing, Marks MRTZ v. State. And what happened in Marks was, much as in this case, an alternate was mistakenly left with the jury, with the pettit jury. The jury went out to deliberate. They notified the court that they have a verdict. And it was at that point, and only at that point, that the bailiff realized, hey, there's 13 people back there and we now have a verdict. The trial judge in that case brought the juror out, removed the alternate, and instructed them that, and as we point out in the brief, in that case, in March, the trial judge instructed them to start over again. He did not instruct them to disregard anything the alternate said. Nevertheless, the jury came back and convicted. But imagine in that case, if no one had caught it, and you have 13 people come in the room and a verdict is received at that point, the record would be clear that that was a verdict that was arrived at by 13 people. Imagine still that after that verdict, the trial court, as Judge Langley did in this case, pulled those jurors, and you have 13 jurors saying, yes, that's my verdict. Yes, that's my verdict. The record would be crystal clear under those circumstances that that was a verdict that was received and an ultimate verdict arrived at by 13 people in violation of Article 5, Section 13. And it wouldn't require an affidavit. And so I think that goes back to the point that you were making, Chief Justice Gray. There, as far as the admissibility of the affidavit, there are ways you could have a constitutional error or a constitutional issue under Article 5, Section 13 without the need for a juror affidavit that's admitted to show the existence or non-existence of an outside influence.
Well, in fact, if the analysis is that the 13th, the alternate juror is not part of the panel. In this case, I should know the 13th juror's name by now, but the alternate juror could provide the affidavit because they are not part of the jury.
By that analysis, yes, I guess theoretically that may be true. But, you know, we've spent time, and time was spent by appellant in the briefings, and we spent a lot of time here today talking about what Mr. Thibodeau referred to as statutory construction of 3301 and 33011B, this question of what to do with the alternates. And I want to kind of take a step back and make this point. There is no question, zero question under the law that whether we are talking about a constitutional allegation of error under Article 5, Section 13, or a statutory allegation of error under 3622, there is no question that harm analysis applies. And I want to go back to an argument that Mr. Thibodeau just made just moments ago. He said, harm is the vote, error is the vote. And he talked about if effect is to be given to Article 5, Section 13, then we have to give this appellant a new trial. What he's seeking to do with that argument is to create out of thin air a structural error where one expressly does not exist, because this is not structural error. It's just not. The United States Supreme Court said in Williams versus Florida, the right to a 12-person jury is not a fundamental right under the 6th Amendment to the United States Constitution. And the Court of Criminal Appeals has stated, I believe it was in Motilla, v. State, and I think they've said it in other cases too, but Motil is the one that's coming to mind, that only rights that the United States Supreme Court has deemed fundamental under the federal Constitution can be regarded as structural, meaning immune from harm analysis. And in fact, at the motion for new trial level, and if you look in the record of the hearing on the motion for new trial, Mr. Thibodeau expressly, overtly argued that this was structural error. On his initial appeal to this court, he expressly argued in his brief that it was structural error. But under the law, it's simply not. It is subject to a harm analysis. And I was here the last time that this court heard oral argument on this case, and Chief Justice Gray, I recall you asking Mr. Thibodeau the direct question, how was Joe Becerra harmed in this case? And he didn't really have an answer. He didn't have one then, and he doesn't really have one now, other than a conclusory statement of the participation is the harm, the vote is the harm. But that's not backed up by anything in the record, when in fact, the record shows that beyond a reasonable doubt, let alone a lesser standard, that Joe Becerra was not harmed by the participation of the alternate. And I want to follow that up by addressing a concern that Mr. Thibodeau raised both in the briefing and here today. This notion of to find harmless error in this case would be to essentially remove all meaning from Article 5, Section 13, and that any verdict, as I think appellant said in his brief, any verdict by more than 12 jurors would, according to the appellant in this case, be immune from harm analysis. And that's simply not true. This decision that this court is making today is not going to extend beyond any fact pattern or any set of circumstances beyond this one and this record, because when you're talking about harm analysis, it is a very fact-specific thing. And just off the top of my head, I can imagine a whole lot of circumstances where you have a jury who is deliberating for a long period of time, and there's notes coming out indicating consternation in the jury room and dispute in the jury room, and they're really struggling with whether or not to convict a defendant. Under circumstances like that, you may have a different case because remember, if a verdict is reached, like the hypothetical example I gave with respect to Marks, if no one had caught that alternate being there and those 13 people had rendered a verdict, that constitutional error under Article 5, Section 13 mandates reversal unless the record shows beyond a reasonable doubt it was harmless. And if you've got that scenario where there's consternation in the jury room and jury notes indicating a struggle or a long period of deliberation, you're not going to be able to rebut that harm. Here, however, you've got a juror affidavit saying that the alternate participated. There's nothing in that affidavit that the alternate influenced anybody or said anything, let alone anything outside the record, which under 3622 is the whole point, to avoid outside influence, meaning influence from things outside the evidence in the case. There's no evidence of that whatsoever here. And you have the 12 pettit jurors having been notified of the alternate status, nevertheless, finding that the defendant in this case actually used, not only possessed, but actually used a firearm.
Okay, what about preservation? Because we always have to look at preservation. At the time that the motion for mistrial was made, the instruction had been given or was about to be given, or
yes, sir.
Given shortly thereafter. No objection to the adequacy of the motion, no objection or request for an instruction made, went straight to the kill shot.
Correct.
Motion to dismiss or for a mistrial.
Yes, sir. As far as whether I believe trial counsel preserved error, we obviously took the position on the initial go around of this appeal that he did not. He should have objected sooner than he did.
Yeah, that was a timing question.
It was. I cannot sit here and say that trial counsel did not preserve error. I mean, he did make a motion for new trial, as Mr. Thibodeau absolutely correctly pointed out.
Okay, that gets then to the question, okay, preserved error, but there's also the rule that if a if something less than a mistrial,
That's correct.
could have been accomplished at this point.
That's correct. And
Are you saying that you don't think there is any instruction that could have been given at that point that would have fixed this problem? Because JD was looking for solutions.
he was, and to directly answer your Honor's question, no, I don't think that. I think there is an instruction that trial counsel could have asked for in that moment that would have been less than a mistrial, specifically the same or the addition of an instruction that the trial court gave in March. So in March, as I said earlier.
Well, didn't you request an
I
instruction
did.
to get a new vote in this case? But it was made before the motion for mistrial.
I don't think I specifically requested a new vote, if memory serves, and going back to the record, I believe what I requested was essentially an instruction to start over.
Okay, well, to me, start over includes
Yes,
a vote ultimately.
Yes, sir, and that is what I had requested. Judge Langley, I can't speak to why that didn't happen. I
In
don't
your
know.
opinion, that would have fixed it.
I believe it would. Yes, there's no question it would have fixed it. I mean, that was the issue in March, is they found that was harmless. What was interesting to me, one of the things that was interesting in March is the trial judge in that case did instruct the jurors to start over. Did not instruct them, as Judge Langley did, to disregard the alternate, but then the March trial judge did instruct them, almost word for word, as Judge Langley did, that the alternate never should have been there, the alternate never should have participated in this process. And so that one sentence of start over was the only thing that was different. And the fact that Judge Langley did instruct them to disregard the alternate, the judge in March did not. But yes, I think that had Judge Langley given that instruction, I can't speak for my friend Mr. Thibodeau, but I don't know that we'd be sitting here talking about it today. I did want to go back to a point.
Make it quick.
Yes, sir, very quickly, that you made when you were talking to Mr. Thibodeau. You correctly pointed out an important word in that opinion, which is that word ultimate verdict. But there's another word that was in Trinidad that I wanted to draw your attention to that went along with it. The ultimate verdict received. And that word received is in the Trinidad opinion. And I think that goes directly back to the question that you started off with, Chief Justice, which is at the time this was caught at 10:31 a.m. and we first started talking about this in the courtroom, no one knew there was a verdict because the court hadn't received a verdict yet. And the jury hadn't announced that they had convicted or voted on guilt at the time that alternate status was revealed, and they were told to disregard it. And so I think those two words work in conjunction to go to the point that you made. The ultimate verdict received, and neither had happened in this case.
Thank you, counsel. Any other questions?
Thank you, Your Honor.
Thank you.
Judge, Justice Gray, I'm going to start where Mr. Calvert ended. And that is the same sentence, because I do think it's important. The sentence after this ultimate verdict language in Trinidad on page 28, the Court of Criminal Appeals says, as long as the only 12 jurors voted on the verdict, as long as only the 12 regular jurors voted on the verdicts that appellant received, it cannot be said they were judged by a jury of more than the constitutionally required number. And that's my point here, is that Becerra was in fact judged by more than what is constitutionally required because there was no revote. Remember, at the time that the instruction was given, there is an overt reference to the second note, the second of the two notes that was received, which showed that the jury was deliberating on the special issue. So to say that there wasn't some kind of notification or there wasn't some clue, given the record as it existed at that time, that they were not deliberating on the special issue and were past the guilt innocence verdict form is not quite accurate. And in addition to that, you still have the whole issue of the motion for new trial. And that's the whole purpose of post verdict motions for new trial, is so that additional information that wasn't available to the trial judge, in this case JD Langley, can be made available and a decision made. I'm going to also talk about, with the 3 minutes I have left, look, I disagree to the extent that I disagree to the extent that the constitutional and the statutory, although they're separate mechanisms, and certainly I get a benefit on the harm analysis under a constitutional violation. In Trinidad, the language of the Court of Criminal Appeals is pretty clear when they is, I think, completely clear when they write the error in these cases, and that is talking about the constitutional dimension, if any, in allowing alternates to be present with the regular jurors during their deliberation is more usefully conceived of as an error in allowing an outside influence to be brought to bear on appellants' constitutionally composed 12-member juries. It's basically, the court is saying in that sentence that essentially the analysis on the undue influence is dispositive. You've got vote, and the way that we're conceiving this error is whether or not this alternate is an outside influence under 36.22. They're basically using the statutory analysis to determine error. And that's why whether or not this alternate is part of the composed jury is so critical, in my opinion. Because if you take the position that the alternate is not part of the composed jury, and the reason we know they're not part of the composed jury is because there's evidence in this case that they voted on the verdict. I will also say that you know, I footnoted something about structural error in my original brief done 3.5 years ago. And on remand, I've taken the position that this is a constitutionally dimensioned issue under Rule 44A, and that continues to be my contention. And it's my contention that because this alternate juror was not part, because they voted of the constituted jury, they were an outside influence. And let me say that I do believe that because they did vote, and there was no, and in fact, instruction that Judge Langley gave, and he was searching, but where he made the critical mistake was say, just resume your deliberations. That at the end says, go ahead and go. And Judge Smith, with respect, a judge I've tried cases in municipal court, county court, and district court to juries with, at the motion for new trial stage was aware of all of this information. And it was proper to grant a motion for new trial under the rebuttable presumption. Remember the rebuttable presumption. If there is an outside influence, then there is a rebuttable presumption that the state just hasn't rebutted. That's all I have. Thank you, Judge.
Thank you, Counsel.
Thank you, counsel. This case is submitted and y'all are excused.
Thanks, sir.